Thank you, sir. May I now request Justice Sanjeev Khanna, Honorable the Chief Justice of India, to kindly address this illustrious gathering.
Honorable the President of India, Srimati Draupadi Murmuji, Shri Justice B.R. Gavai, Chief Justice of India Designate and Judge Supreme Court of India, Shri Arjun Ram Meghwal, Minister of State for Law and Justice, Shri R. Venkataramani, Attorney General of India, Shri Tushar Mehta, Solicitor General of India, Shri Manan Kumar Mishra, Chairperson, Bar Council of India, esteemed judges, retired judges of the Supreme Court of India, Chief Justices, judges of the High Courts, members of the judiciary, including the bar. It is an honor to address you all today on the subject that is quietly but surely transforming the way we think about justice, samjhauta or mediation. As mediation increasingly gains limelight in our legal and institutional discourse, I often hear a recurring observation that mediation is intrinsic to Indian culture, woven in the very fabric of how we have historically resolved our disputes. It is said mediation reflects our instinctive preference for resolution through dialogue, through consensus. I am reminded of the twin pillars that anchor India's constitutional ethos: Nyay, that is justice, and Samvad, that is dialogue. This observation carries truth. For centuries, informal mediation has been part of our communities. But at the very outset, I must add a word of caution. First, mediation is not the mainstream. It is not the first choice in India. Secondly, while this traditional instinct is indeed valuable, it is important to recognize that modern mediation is different. It is not merely an informal negotiation. It is a disciplined, structured, confidential, and a neutral process. To understand the sea chain it can bring to disputed resolution, we must have a look at what mediation is. Let me begin by drawing a simple parallel. Courtroom adjudication is often to disputes and parties what most medicines are to ailments. They treat the symptoms and provide relief, which makes us feel better. Court litigation is somewhat similar. One party is right, the other is wrong. In this way, the court litigation and adjudication are grim and shallow. At times, the root cause remains unaddressed, and the ailment and pain remains. The relationships are strained, if not broken. There is a winner, there is a loser. Mediation does the opposite. It seeks to identify and remedy the root cause. It goes deeper into the issue, the cause of the misunderstanding. It addresses the primordial and the underlying concerns that are the cause of the dispute. It allows a more holistic solution, one that not only resolves the legal issue, but goes beyond that. It heals and restores the relationship. This is true justice, not coerced and forced by third parties' dictate. Because the process is voluntary and participatory, the solution reached is less traumatic, more humane, and more acceptable. This brings us to the role of the mediator. How different it is from that of a judge or an advocate. In the courtroom, the role of the judge is to decide. The court decision often involves fault finding, even when we apply the law. The decision is to uphold justice as prescribed by law. Our advocates, by very nature, are argumentative. They give legal shape to the disputes. They make the litigation more complex. The role of the mediator is different. A mediator must go beyond binaries. Not every dispute or should be reduced to right, wrong, or fault finding. Often disputes exist in the shades of grey, where the personal commercial frictions do not always arise from one side being wrong, but also from misunderstanding. In many cases, both are at fault, though degrees may vary. Mediation offers space for undoing complexities. It does not involve legal and procedural complexities. It is flexible and personalized, not bound by rigid procedure. And above all, is it empathetic, aiming not to win over the other side, but to bring them together. To truly appreciate mediation, it is thus essential to understand how the mediator proceeds and requires a different skill set. A mediator must follow the process to be party driven. Mediators guide the parties without judging them and do not decide the outcomes. The parties are given adequate and fair opportunity to be heard and are allowed to vent their grievances. Mediators facilitate a process which the parties can speak openly. This also is possible because mediation is voluntary and confidential. The outcome is a result of consensus and settlement. This is where the neutrality of the mediator becomes crucial. In contrast to traditional notion of resolving disputes through community elders, modern mediation benefits from the distance of a third party. Someone who comes to the conversation with no prior notions, no assumption, no biases. It is often the case that one finds it easier to open up to a stranger. With someone unfamiliar, we feel less judged, free to speak ourselves, our truth, and our grievances. It is said that a mediator is like a psychologist who must be trained to listen deeply and to understand patiently. A skilled mediator senses not only what is being said, but also what lies beneath the words. In this way, they equip the parties with the right tools to arrive at their own solution. I have gone through the new Mediation Act 2023. There is one portion of the Act which has not been referred to and not ever elucidated, and that is Section 43. 43 of the Mediation Act provides for community mediation. Disputes likely to affect peace, harmony, and tranquility among residents of families of specific area or locality may be resolved through community mediations. This is an important step forward. The founding parents of our Constitution envisaged that provisions ought to be made for securing social justice in our Constitution. Our preamble categorically asseverates that endeavors must be made to secure justice, economic, social, political, to our people. I want to underscore the term social justice here, for it is through mediation that the social justice is achieved. Over the past 8 years or so, mediation has consistently played, over the past about 2 decades, mediation since 2005, mediation has consistently played a critical role in resolving disputes with case settlement numbers reflecting both resilience and recovery. Between 2016 and early 2025, a staggering 7,57,173 cases were settled through mediation. Yet, I must acknowledge that mediation is still to reach the homes and at the villages. We are still at the periphery. India, in one way, therefore, has been slow to arrive at the mediation and understand its importance. Our goal must be to show every litigant, every person, every businessman, every citizen that the mediation is not a lesser form of justice, but a wiser form of it. My resolve and belief in this mission is made stronger by the presence of the Honorable President today's gathering. Her extraordinary journey and wisdom are rooted in knowing the pulse of the nation. She serves as a constant inspiration in realizing that we must devise solutions with emphasis with the people's reality and mirror their aspirations. Thank you and Jai Hind.